Thank you for listening to Lone Star Community Radio. This program was broadcasted and recorded live from the LSCR studios in downtown Conroe, Texas. Lone Star Community Radio is supported by listeners like you. Donate and sponsor today. For more information on getting involved with Lone Star Community Radio, contact us at lscrstudios@gmail.com or visit us online at www.irlonestar.com.
Hi, welcome to the Legal Connection Show. I'm Tony Collins, an attorney licensed in Texas, and the Legal Connection Show airs on Tuesdays at noon for an hour each week. And it is a public service program to answer legal questions for the community here in the Conroe and Montgomery County area. You can get us at FM 104.5 or FM 106.1 if you're within the band frequency of the radio station. Otherwise, you may be listening on our Facebook site, the Legal Connection Show. You can also go to irlonestar.com, and all of the shows are recorded, and you can go back and see a previous one. Like in today's show, it's going to be a part 5 of Roe v. Wade. It's the last segment of sort of dissecting and analyzing the original Roe v. Wade opinion and the opinion that has not actually been formally released by the United States Supreme Court, but it was leaked to a publication called Politico, and it is what appears to be the actual opinion by the court that's going to reverse Roe v. Wade, and that particular case is Dobbs v. Jackson Women's Health Organization. So we're going to pick up where we left off, and rather than me give any opinions on Roe v. Wade or Dobbs v. Jackson, I'm going to actually read the actual case because it's written so much better than I could ever say it, and it's written in sort of layman's terms, so it's really easy to understand. And the gist of this case, just to recap briefly, is that there was a law in the state of Texas back in 1970, I believe it was, that prohibited abortion after the 15th week, with some exceptions. And a couple of new lawyers from the University of Texas that were in their early 20s decided that they wanted to raise the issue of whether or not the Texas law was constitutional, and that being whether the United States Constitution was being violated by this law and to overturn the law, which it was. And so this Dobbs v. Jackson, which is basically 50 years later, almost to the day, maybe they're waiting to release it, so it's released on the same day, so it's 5 decades later. But it actually is a very well-written opinion that tracks the constitutional laws and sets out succinctly and logically why Roe v. Wade was wrong and why it doesn't violate the Constitution. So I'm going to pick up where we left off and basically read the opinion of the court. And bear with me if you're watching this because I left my readers at another location I was at Spring earlier today. So I'm reading without my readers, which is going to be a little bit tough, but I think I can do it. Okay, so the opinion of the court, where we left off, was at page 28, and it sounds like this is going to be boring, but truly there's only about 20 more pages, but it's just so well written. You really have to hear the words. I can just hear Justice Alito saying these words out loud, and they make so much sense. So sort of disregard what your opinion may be on abortion and pro-choice, pro-life, because this just really gets down to the crux of the matter, and that is whether or not particular state laws, in this case it was Mississippi state law, violate the Constitution by overstepping the bounds that are allowed. And in this case, Justice Alito is saying they don't, and this is a states' rights issue. It was never unconstitutional per our United States Constitution. All right, so to pick up where we left off, another amicus brief, and you can almost hear Justice Alito saying this. Another amicus brief relied upon by the respondents tries to dismiss the significance of state criminal statutes that were in effect when the 14th Amendment was adopted by suggesting that they were enacted for illegitimate reasons. According to this account, which is based almost entirely on statements made by one prominent proponent, important motives for the laws were the fear that Catholic immigrants were having more babies than Protestants, and that the availability of abortion was leading white Protestant women to shirk their maternal duties. That was a brief for the Amici Curie, American Historical Association, organization of American historians, a long name for just somebody that wrote a brief that was supporting that that Roe v. Wade should be found to our Texas statute was not in violation of the Constitution. Resort to this argument is a testament to the lack of any real historical support for the right that Roe and Casey, which was a case that came out after Roe that sort of broke it down a little bit but still didn't overturn it, recognized. The court has long disfavored arguments based on allegations on, and this is me without my glasses on, sorry. The court has long disfavored arguments based on alleged legislative motives. The court has recognized that inquiries into the legislative motives, quote, are a hazardous matter. Even when an argument about legislative motive is backed by statements made by legislators who voted for a law, we have been reluctant to attribute those motives to the legislative body as a whole. What motivates one legislator to make a speech about a statute is not necessarily what motivates another or scores of others to enact it. Here, the argument about legislative motive is not even based on statements by the legislators, but on a statement made by a few supporters of the new 19th century abortion laws. And it is quite a leap to attribute these motives to all legislators whose votes were responsible for the enactment of those laws. Recall that at the time of the adoption of the 14th Amendment, over 3/4 of the states had adopted statutes criminalizing abortion, usually at all stages of pregnancy, and that from the early 20th century until that day, Roe was handed down. Every single state had such laws on its books. So I believe that the 14th Amendment, I don't have any footnotes here, was passed in 1868. And what Justice Alito is saying is that that when the 14th Amendment was passed, which was the basis for Roe overturning the Texas state law that prohibited abortion, so it allowed it at that point. They were saying that they used the 14th Amendment, but even when the 14th Amendment was enacted, every one of the states had laws that were stricter than the one that they were trying to overturn. Are we to believe that hundreds of lawmakers whose votes were needed to enact these laws were motivated by the hostility to Catholics and women? There is ample evidence that the passage of these laws, and that means laws that prohibited abortion, was instead spurred by a sincere belief that abortion kills a human being. Many judicial decisions from the late 19th and early 20th centuries made that point. One may disagree with this belief, and our decision is not based on any view about when a state should regard prenatal life as having rights or legally cognizable interest. But even Roe and Casey did not question the good faith of the abortion opponents. Quote, men and women of good conscience can disagree about the profound moral and spiritual implications of terminating a pregnancy even in its earliest stage. And that's a quote from Casey, which was a 2007 case. And we see no reason to discount the significance of the state laws in question based on these amici suggestions and legislative motive. Instead of seriously pressing the argument that the abortion right itself has deep roots, supporters of Roe and Casey contend that the abortion right is an integral part of the broader entrenched right. So they didn't argue in Roe or Casey that the previous laws that were carried out by the legislatures had anything to do with, in any way, mirrored that abortion was something that should be a right to the individual, because they couldn't have done that, because the stare decisis set out that abortion was prohibited back during the 14th Amendment, and even when Roe was passed, when the decision was handed down that overturned laws that prohibited abortion. So they weren't using stare decisis at all. Instead, they were trying to use the Constitution as the basis for it being violated, a right being violated, but it simply wasn't. And this is what Justice Alito is going to go on to tell us. Roe termed this a right to privacy, abortion as a right of privacy. Casey described it as a freedom to make, quote, intimate and personal choices that are central to the personal dignity and autonomy. Casey even elaborated, at the heart of liberty is the right to define one's own concept of existence, of meaning, of the universe, and the mystery of human life. The court did not claim that this broadly framed right is absolute, and no such claim would be plausible. While individuals are certainly free to think and to say what they wish about existence, meaning, the universe, and the mystery of human life, they are not always free to act in accordance with those thoughts. License to act on the basis of such beliefs may correspond to one of the many understandings of liberty, but is certainly not an ordered liberty under the Constitution. And the footnote says here, other amicus briefs present arguments about the motives of proponents of liberal access to abortion. They note that some such supporters have been motivated by a desire to suppress the size of the African American population. And it is beyond dispute that Roe has had that demographic effect. A highly disproportionate percentage of aborted fetuses are black. For our part, we do not question the motives of either those who have supported and those who have supported laws restricting abortions. We're strictly looking at the Constitution and the rights that are set out therein. Ordered liberty sets limits and defines the boundaries between competing interests. Roe and Casey each struck a particular balance between the interest of a woman who wants an abortion and the interest of what they termed, quote, potential life. But the people of the various states may evaluate those interests differently. In some states, voters may believe that abortion rights should be even more extensive than the right that Roe or Casey is recognized. Voters in other states may wish to impose tight restrictions based on their belief that abortion destroys an, quote, unborn human being. Our nation's historical understanding of ordered liberty does not prevent the people's elected representatives from deciding how abortion should be regulated, nor does that right to obtain an abortion have a sound basis in precedent. Casey relied on cases involving the right to marry a person of a different race. And then they go on to quote other cases that show what different rights were. Loving versus Virginia in 1967 talked about the right to marry while in prison. Turner v. Safley in 1987, the right to obtain contraceptives. Griswold versus Connecticut in 1965, and Baird and Carey versus the Population Services International discuss the right to reside with relatives. Moore versus East Cleveland in 1977, the right to make decisions about the education of one's children. Pierce versus the Society of Sisters in 1925, as well as Meyer versus Nebraska in 1923, discussed the right not to be sterilized without consent. That's pretty. We're going into very extreme circumstances of rights here. Skinner versus Oklahoma discusses the right in certain circumstances not to undergo involuntary surgery, forced administration of drugs, or other substantially similar procedures. Respondents and the Solicitor General also rely on post-Casey decisions like Lawrence versus Texas in 2008, which discussed the right to engage in private consensual sexual acts, and Obergefell versus Hodges, which is a 2015 case, which deals with the right to marry a person of the same sex. These attempts to justify abortion through appeals to a broader right to autonomy. That way it's phrased didn't look right to me at all. These attempts to justify abortion through appeals to a broader right to autonomy and to define one's concept of existence prove too much. And that's a quote from Casey. Those criteria, at a high level of generality, could license fundamental rights to illicit drug use, prostitution, and the like. So you could argue the other side, too. If you can argue, according to Justice Alito, that abortion is a right to an individual based on the Constitution, then you could also argue that the rights to use and sell illicit drugs be involved in prostitution, whether the receiver or the giver, and other activities like that could be argued to also be covered by the Constitution and a right that you can conduct on your own based on those rights. And it's just simply not. Those are acts that the Constitution doesn't discuss those acts of morality or immorality, depending on, I guess, how you, the scope of how you want to identify those illicit acts. None of these rights has any claim to being deeply rooted in history. What sharply distinguishes the abortion right from rights recognized in the cases on which Roe and Casey rely is something that both decisions acknowledged, and that is, abortion destroys what those decisions call, quote, potential life, and what the law at issue in this case regards as the life of, quote, an unborn human being. None of the other decisions cited by Roe and Casey involve the critical moral question posed by abortion. They are, therefore, inapposite. They do not support the right to obtain an abortion, and by the same token, our conclusion that the Constitution does not confer such a right does not undermine them in any way. In drawing this critical distinction between the abortion right and other rights, it is not necessary to dispute Casey's claim, which we accept for the sake of argument, that the specific practices of states at the time of the adoption of the 14th Amendment do not mark the outer limits of the substance sphere of liberty, which the 14th Amendment protects. Abortion is nothing new. It has been addressed by lawmakers for centuries, and the fundamental moral question that it poses is ageless. Defenders of Roe and Casey do not claim that any new scientific learning calls for a different answer to the underlying moral questions, but they do contend that changes in society require the recognition of a constitutional right to obtain an abortion. Without the availability of abortion, they maintain, people will be inhibited from exercising their freedom to choose the types of relationships they desire, and women will be unable to compete with men in the workplace and and other endeavors. Americans who believe that abortion should be restricted press countervailing arguments about modern developments. They note that the attitudes about the pregnancy of unmarried women have changed drastically, that federal and state laws ban discrimination on the basis of pregnancy, that leave for pregnancy and childbirth are now guaranteed by law in many cases, that the cost of medical care associated with pregnancy are covered by insurance, or government assistance, that states have increasingly adopted safe haven laws, which generally allow women to drop babies off anonymously, and that a woman who puts her newborn up for adoption today has little reason to fear that the baby will not find a suitable home. They also claim that many people now have a new appreciation of fetal life, and that when prospective parents who want to have a child view a sonogram, they typically have no doubt that what they see is their daughter or son. Both sides make important policy arguments. Both supporters of Roe and Casey must show this court has the authority to weigh those arguments and decide how abortion may be regulated in the states. They have failed to make that showing, and we thus return to the power to weigh those arguments to the people and their elected representatives. So as we discussed in the first 4 parts of this series, the 10th Amendment, what gives the right to a federal court to make a determination, a decision on whether a law is constitutional or not, as is a right that's given under the Constitution, under the 10th Amendment. Anything not given to the federal government under the 10th Amendment is reserved to the states. They didn't argue the 10th Amendment in Roe nor Casey, because had they argued the 10th Amendment, they would have lost, because clearly this is a 10th Amendment issue and it's a states' rights issue. So this is what he's probably going to go on to say, and I'm foreshadowing it because I have not read this entire opinion. We're reading it for the first time together. We next consider whether the doctrine of stare decisis counsels continued acceptance of Roe and Casey. Stare decisis plays an important role in our case law, and we have explained that it serves many valuable ends. It protects the interest of those who have taken action in reliance upon a past decision. It reduces incentives of challenging settled precedents, saving parties and courts the expense of endless relitigation. It fosters even-handed decision making by requiring that cases be decided in a like manner. It contributes to the actual and perceived integrity of judicial process. And it restrains judicial hubris and reminds us to respect the judgment of those who've grappled with important questions in the past. Precedent is a way of accumulating and passing down the learning of past generations, a font of established wisdom richer than can be found in any single judge or panel of judges. We have recognized, however, that stare decisis is not an inexorable command, and it, quote, is at its weakness when we interpret the Constitution. It has been said that it is sometimes more important that an issue be settled than it be settled right. But when it comes to the interpretation of the Constitution, the great charter of our liberties, which was meant to endure through a long lapse of ages, we place a high value on having the matter as a settled right. In addition, when one of our constitutional decisions goes astray, the country is usually struck with the bad decision unless we correct our own mistake. An erroneous constitutional decision can be fixed by amending the Constitution, but our Constitution is notoriously hard to amend. Therefore, in appropriate circumstances, we must be willing to reconsider and if necessary, overrule constitutional decisions. And, I'm reading this and it just reminds me of, homeowners associations, because I'm on the board of a homeowners association and I have land where I'm not on the board, but I'm governed, or my land is governed by those rules. And likewise, it is notoriously difficult to get an amendment passed to change a covenant in your deed restrictions and by a homeowners association. It's just difficult, and it's the same thing. That is, your restricted covenants are like your constitution, and here it is very difficult to get the constitution. You have to have a constitutional amendment, or you have to have a Supreme Court determine that as they interpret the Constitution, a particular law may or may not be violated. Stare decisis is so important that is why when you lose a case in state court that has violated a United States Constitution, a right that is clearly expressed and has been held a right by stare decisis for over 200 years, that you should certainly apply for a petition for writ certiorari to have the United States Supreme Court determine whether or not your particular state case is not following your rights under the Constitution. Clearly, this is the type of case that the Supreme Court would grant a petition for writ of certiorari on, because otherwise you don't have something that can be relied upon, just like they were talked about in the previous paragraphs that were set out so succinctly by Justice Alito. Now, some of our most important constitutional decisions have overruled prior precedents. We mentioned 3. In Brown versus the Board of Education, the court repudiated the separate but equal doctrine, which had allowed states to maintain racially segregated schools and other facilities in 1954. In so doing, the court overruled the infamous decision of Plessy v. Ferguson of 1896, along with 6 other Supreme Court precedents that had applied to the separate but equal rule. So Plessy v. Ferguson is a case that you learn when you go to law school. It's like one of the first ones you learn in constitutional law, that was decided in 1896, that basically set out that you're still treating people equally, but you can treat them equally in separate facilities. And it took a full 58 years for Brown versus the Board of Education, which is when a lot of civil rights was coming about, for them to decide that that doctrine is flawed. You can't have separate facilities and require people to be in separate schools and have separate bathrooms and eat in separate parts of a restaurant and not be on the same bus. You can't separate people out racially, because you are not treating them equally. And so while the Constitution said all people will be treated equally, and I'm paraphrasing here because I haven't read those particular cases, there was an erroneous decision made in Plessy v. Ferguson and some subsequent Supreme Court cases that was corrected by Brown versus the Board of Education. And it's been followed ever since. And truly, if you read the Constitution expressly and don't try to interpret something that's not written in there, Brown versus the Board of Education was clearly the correct decision. And it took a strong Supreme Court in 1954 to come through and say that was wrong. In West Coast Hotel versus Parrish in 1937, the court overruled Atkins versus Children's Hospital of D.C. in 1923. So that was a shorter wig. They had made a ruling in 1923. They overruled it, looks like it would be 13 years later. Those cases, when they overruled it, the court had held originally that a law setting minimum wages for women violated the liberty protected by the Fifth Amendment's Due Process Clause. West Coast Hotel in 1937 signaled the demise of an entire line of important precedents that had protected an individual liberty right against state and federal health and welfare legislation. In Loebner versus New York in 1905, holding invalid a law setting maximum working hours. And then it goes on to talk about Coppage versus Kansas in 1915, holding invalid a law banning contracts forbidding employees to join the union. And then there was J. Burns versus Bryan in 1924, holding invalid laws fixing the weight of loaves of bread, one I've never heard of. Finally, in West Virginia Board of Education versus Barnett in 1943, after the lapse of only 3 years, the court overruled Minersville School District versus Gobetus, I'm just slaughtering that name, of 1940, and held that the public school students could not be compelled to salute the flag in violation of their sincere beliefs. Wow, they were all the way back in 1940 and 1943 during the Second World War, when there was so much patriotism and we were fighting to keep our rights and our freedom of democracy. People were still not wanting to pledge allegiance to the flag. This goes on to say that Barnett, that is the current law, stands out because nothing had changed during the intervening period other than the court's belated recognition that its earlier decision had been seriously wrong. On many other occasions, the court had overruled important constitutional decisions. We conclude a partial list in the footnote that follows, which I'm not going to read because it's too confusing to try to read what each one of the cases said and what they overruled and what they stand for now. Instead, we're going to talk only about this case. With these decisions, oh my gosh, the footnote lasts for a full, looks like 23 font single-spaced page. There were many, many times when the court has overruled itself. This says the American constitutional law, as we know it, it would be unrecognizable, and this would be a different country. So, no justice of this court has ever argued that the court should never overrule a constitutional decision, but overruling a precedent is a serious matter. It is not a step that should be taken lightly. Our case has attempted to provide a framework for deciding when a precedent should be overruled, and they have identified factors that should be considered in making such a decision. In this case, 5 factors weigh strongly in favor of overruling Roe and Casey, and they are the nature of their error, the quality of their reasoning, the workability of the rules they impose on the country, their disruptive effect on other areas of the law, and the absence of concrete reliance. The nature of the court's error is the first one they discuss. An erroneous interpretation of the Constitution is always important, but some are more damaging than others. And Justice Alito is putting this as the first reason that there was a strong factor for overruling Roe, means that he believed that the nature of the court's error was the most important error. The infamous decision of Plessy v. Ferguson was one such decision. It betrayed our commitment to equality under the law, as I tried to very poorly describe. He's going to describe it better for me, Justice Alito. It was egregiously wrong on the day it was decided. It should have been overruled at the earliest opportunity. Roe was also egregiously wrong and deeply damaging. For reasons already explained, Roe's constitutional analysis was far outside the bounds of any reasonable interpretation of the various constitutional provisions to which it vaguely pointed. Roe was on a collision course with the Constitution from the day it was decided, and Casey perpetuated its errors, and the errors do not concern some arcane corner of the law of little importance to American people. Rather, wielding nothing but raw judicial power, the court usurped the power to address a question of profound moral and social importance that the Constitution unequivocally leaves for the people. Casey described itself as calling both sides of the national controversy to resolve their debate. But in doing so, Casey necessarily declared a winning side. Those on the losing side, those who sought to advance the state's interest in fetal life, could no longer seek to persuade their elected representatives to adopt policies consistent with their views. The court short-circuited the democratic process by closing it to the large number of Americans who dissented in any respect from Roe. Roe fanned into life an issue that has inflamed our national politics in general and has obscured with its smoke the selection of justices to this court in particular ever since. And there's a footnote that says, Justice Scalia concurring in part and dissenting in part in Casey. Together, Roe and Casey represent an era that cannot be allowed to stand. As the court's landmark decision in West Coast Hotel illustrates, the court has previously overruled decisions wrongly removed an issue from the people and their democratic process. As Justice White later explained, decisions that find in the Constitution principles or values that cannot fairly be read into that document usurp the people's authority. For such decisions represent choices that the people have never made, and they cannot disavow through corrective legislation. For this reason, it is essential that this court maintain the power to restore authority to the proper possessors by correcting constitutional decisions that, on reconsideration, are found to be mistaken. So, in layman's terms, he is saying that a right that should have been given to the people through their legislatures for each individual state was taken away by the decision of Roe, by the judicial branch of the government, when it should have remained a legislative decision that was truly by the people to their legislatures, so that could become a law to the states and not something that was ruled to be a violation of the supreme law under the Constitution, that was not relegated or delegated to the judiciary. Now, the next factor that he said weighed heavily, Justice Alito, in favor of overruling Roe and Casey, is the quality of the reasoning. Under our precedents, the quality of the reasoning in the prior case has an important bearing on whether it should be reconsidered. And I'm trying to skip over the part that would be difficult to read with all the citations. Justice Kavanaugh explained and concurred in Janus State versus Municipal Employee. In Part 2 of this opinion, the Supreme Court explained why Roe was incorrectly decided, but that decision was more than just wrong. It stood on exceptionally weak grounds. Roe found that the Constitution implicitly conferred a right to obtain an abortion, but it failed to ground its decision in text, history, or precedent. It relied on an erroneous historical narrative. It devoted great attention to and presumably relied on matters that have no bearing on the meaning of the Constitution. It disregarded the fundamental difference between the precedents on which it relied and the question before the court. It concocted an elaborate set of rules with different restrictions for each trimester of pregnancy, but it did not explain how this veritable code could be teased out of anything in the Constitution. The history of abortion laws, prior precedent, or any other cited source, and its most important rule, and that is that states cannot protect fetal life prior to viability, was never raised by any party and has never been plausibly explained. Roe's reasoning quickly drew scathing scholarly criticism, even from the supporters of broad access to abortion. The Casey plurality, while reaffirming Roe's central holding, pointedly refrained from endorsing most of its reasoning. It revised the textual basis for the abortion right, silently abandoned Roe's erroneous historical narrative, and jettisoned the trimester framework altogether. But it placed that scheme with an arbitrary, quote, undue burden test, and relied on an exceptional version of stare decisis that, as explained below, this court had never before applied and has never invoked since. The weaknesses in Roe's reasoning are well known. Without any grounding in the constitutional text, history, or precedent, it imposed on the entire country a detailed set of rules, much like those that one might expect to find in a statute or regulation. Dividing pregnancy into 3 trimesters, the court imposed specific rules for each. During the first trimester, the court announced the abortion decision and its effectiveness must be left to the medical judgment of the pregnant woman's attending physician. After that point, a state's interest in regulating abortion for the sake of the woman's health became compelling, and accordingly, a state could regulate the abortion procedures in ways that are reasonably regulated to the maternal health. And finally, in the stage subsequent to viability, which in 1973 roughly coincided with the beginning of the 3rd trimester, the state's interest in the potentiality of human life became compelling, and therefore a state could regulate and even prescribe abortion except where it was necessary in appropriate medical judgment for the preservation of the life and health of, drumroll, I'm sure this is going to say the mother. The elaborate scheme for the court's own brainchild. This elaborate scheme was the court's own brainchild. Neither party advocated the trimester framework, nor did either party or any amicus argue the viability should mark the point at which the scope of abortion right in a state's regulatory authority should be substantially transformed. Not only did this scheme resemble the work of a legislature, but the court made little effort to explain how these rules could be deduced from any sources on which the constitutional decisions are usually based. We have already discussed Roe's treatment of constitutional text, and the opinion failed to show that history, precedent, or any other cited source supported this scheme. Roe featured a lengthy survey of history, but much of its decision was irrelevant, and the court made no effort to explain why it was included. For example, multiple paragraphs were devoted to an account of the views and the practices of ancient civilizations where infanticide was widely accepted. And they discussed ancient Greek and Roman practices. When it came to the most important historical fact, that is, how the state regulated abortion when the 14th Amendment was adopted, the circuit said almost nothing. It allowed the state had tightened their abortion laws, quote, in the middle and the late 19th century, but it implied, end quote, but it implied that these laws might have been enacted not to protect the fetal life, but to further a Victorian social concern about illicit sexual conduct. Roe's failure even to note the overwhelming consensus of the state laws in effect in 1868 when the 14th Amendment was passed is striking. And what is said about the common law was simply wrong. Relying on 2 discredited articles by an abortion advocate, the court erroneously suggested, contrary to Bracton, Koch, Hale, Blackstone, and a wealth of other legal authority, the common law had probably never really treated post-quickening abortion as a crime. It now appears doubtful that abortion was ever firmly established as a common law crime, even with respect to the destruction of a quick fetus. Now, and they're quoting these cases. He goes on to say, this erroneous understanding appears to have played an important part of the court's thinking because the opinion cited, quote, the lenity of the common law, end quote, as one of the 4 factors that informed its decision in Roe. So in other words, they were bringing facts in that had no basis or precedent. They were just using legal gymnastics for the end what do you say, the means to meet the end, which is not what you're supposed to do when you do a constitutional analysis of when you're overturning a state law, which is legislative and for the people. After surveying history, the opinion spent many paragraphs conducting the sort of fact-finding that might be undertaken by a legislative committee. This included a lengthy account of the position of the American Medical Association and the position of the American Public Health Association, as well as the vote by the American Bar Association's House of Delegates in 1972 on proposed abortion legislation. Also noted were a British judicial decision handed down in 1939 and a new British abortion law enacted in 1967. The court did not explain why these sources shed light on the meaning of the Constitution, and not one of them adopted or advocated anything like the scheme that Roe imposed on the country. Finally, after all this, the court turned to precedent, citing a broad array of cases. The court found support for a constitutional right of personal privacy, but it conflated two very different meanings of the term. The right to shield information from disclosure and the right to make and implement important personal decisions without governmental interference. Only the cases involving this second sense of the term could have any possible relevance to the abortion issue. And some of the cases in that category involved personal decisions that were obviously very, very far afield, including the right to have children receive German language instruction. What remained was a handful of cases having something to do with marriage, the right to marry a person of a different race, the right not to be sterilized, the right of married persons to obtain contraceptives, the right for unmarried persons to receive contraceptives. But none of these decisions involve what is distinctive about abortion. It's the effect on what Roe termed, quote, potential life. When the court summarized the basis for the scheme is imposed on the country, it asserted that its rules were consistent with the following. 1, the relative weights of the respective interests involved. 2, the lessons and the examples of the medical and legal history. 3, the lenity of common law. 4, the demands of the profound problems of the present day. Put aside the second and third factors, which were based on the court's flawed account of history, and what remains are precisely the sort of considerations that legislative bodies often take into account when they draw the lines that accommodate competing interests. The scheme Roe produced looked like legislation, and the court provided the sort of explanation in legal gymnastics that might be expected from a legislative body, not a judicial body. What Roe did not provide was any cogent justification for the lines it drew. Why, for an example, does the state have no authority to regulate the first trimester abortions for the purpose of protecting a woman's life? The court's only explanation was that mortality rates for abortion at that stage were lower than mortality rates for childbirth. But the court did not explain why mortality rates were the only factor that a state could legitimately consider. Many health and safety regulations aim to avoid adverse health consequences short of death, and the court did not explain why it departed from the normal rule that courts defer the judgments to the legislatures in areas fraught with medical and scientific uncertainties. And that was in Marshall versus the United States in 1974. An even more glaring deficiency with Roe's failure to justify the critical distinction it drew between pre- and post-viability abortions is here in the courts, and it's here. I'm going to have to rephrase that because the way it's phrased, the way I put the emphasis is really difficult. An even more glaring deficiency was Roe's failure to justify the critical distinction it drew between the pre- and post-vitality abortions. Here is the court's entire explanation in Roe that this current court is saying made no sense. Roe said, with respect to the state's important and legitimate interest in potential life, the compelling point is its viability. This is so because the fetus then presumably has the capability of meaningful life outside the womb. As Professor Lawrence Tribe has written, quote, clearly this mistakes a definition of syllogism. And that was, I don't even know what year that was. The definition of a viable fetus is one that is capable of surviving outside the womb. But why is this the point at which the state's interest becomes compelling? If, as Roe held, a state's interest in protecting prenatal life is compelling after viability, why isn't that interest equally compelling before viability? Roe did not say and has no explanations. The arbitrary line has not found much support among the philosophers and ethicists who have attempted to justify a right to abortion. Some have argued that a fetus should not be entitled to legal protection until it acquires the characteristics that they regard as define what it means to be, quote, a person. Among the characteristics that have been offered as essential attributes of personhood are sentience, self-awareness, the ability to reason, or some combination thereof. By this logic, it would also open a question whether even born individuals, including young children, or those affected with certain developmental or medical conditions, merit protection as persons. But even if one takes that view, the personhood begins when a certain attribute or combination of attributes is acquired. It is very hard to see why viability should mark the point where personhood begins. The most obvious problem with any such argument is that viability is heavily dependent on factors that have nothing to do with the characteristics of the fetus. One is the state of the neonatal care at that particular point in time. Due to the development of new equipment and improved practices, the viability line has changed over the years. In the 19th century, a fetus may not have been viable until the 32nd or 33rd week after conception, or even later. When Roe was decided, the viability was gauged at roughly 28 weeks. Today, respondents drew the line at 23 to 24 weeks. States now have compelling interest in protecting a fetus with gestational age of, say, 26 weeks. But in 1973, states did not have an interest in protecting an identical fetus. Well, how can that be? Viability also depends on the quality of the available medical facilities. Thus, a 24-week-old fetus may be viable if a woman gives birth in a city with hospitals that provide advanced care for very premature babies. But if the woman travels to a remote area far from any such hospital, the fetus may no longer be viable. On what ground could the constitutional status of a fetus depend on the pregnant woman's location that she gives birth? And if viability is meant to mark a line having universal moral significance, can it be that a fetus that is viable in a big city in the United States had a privileged moral status not enjoyed by an identical fetus in a remote area of a poor country differs? In addition, as the court once explained, viability is not really a hard and fast line. And they said that in Cullaverty, and I don't know what year it was. A physician determining a particular fetus's odds of surviving outside the womb must consider a number of variables, including gestational age, fetal weight, and a woman's general health and nutrition, the quality of the available medical facilities, and other factors. It is thus only with difficulty that a physician can estimate the probability of a particular fetus's survival. And even if each fetus's probability of survival could be ascertained with certainty, setting on a probability of survival that should count as viability is another matter entirely. Is a fetus viable with a 10% chance of survival, 25%, 50%? Can such a judgment be made by a state? And can a state specify a gestational age limit that applies in all cases? Or must these difficult questions be left entirely to the individual attending the physician on particular facts of the case before him? The viability line, which Casey termed Roe's central rule, makes no sense. And it's telling that other countries almost uniformly echo such a line, eschew such a line. The court thus asserted raw judicial power to impose, as a matter of constitutional law, a uniform viability rule that allowed the states less freedom to regulate abortion than the majority of the Western democracies now enjoy. All in all, Roe's reasoning was exceedingly weak, and academic commentators, including those who agreed with the decision as a matter of policy, were unsparing in their criticism. John Hart Ely famously wrote that Roe was, quote, not constitutional law and gave almost no sense of an obligation to try to be. Archibald Cox, who served as Solicitor General under President Kennedy, commented that Roe, quote, reads like a set of hospital rules and regulations, end quote, that, quote, neither historian, layman, or lawyer will be persuaded are a part of the Constitution. Archibald Cox, the role of the Supreme Court in the Amir, and that was from Archibald Cox. Lawrence Tribe wrote that, quote, even if there is a need to divide pregnancy into several segments, which lines that clearly identify the limits of governmental power, interest balancing as a form the court pursues fails to justify any lines actually drawn. Tushnet termed Roe, quote, totally unreasoned judicial opinion. And so Justice Alito goes on to say, despite Roe's weaknesses, its reach was steadily extended in the years that followed. The court struck down laws requiring that second trimester abortions be performed only in hospitals, that women give written consent after being informed of the status of the developing prenatal life and the risk of abortion, that women wait 24 hours for an abortion, that a physician determine viability in a particular manner, that a physician perform a post-viability abortion that a physician performing a post-viability abortion use the techniques most likely to preserve the life of the fetus, and that the fetal remains be treated as human in a humane and sanitary manner. Justice White complained that the court was engaging in an unrestrained imposition of its own extra constitutional value preferences, and the United States, as amicus curiae, asked the court to override Roe 5 times in the decade before Planned Parenthood versus Casey, and then asked the court to overrule it once more in Casey itself. When Casey revisited Roe almost 20 years later, very little of Roe's reasoning was defended or preserved. The court abandoned any reliance on the privacy right and instead grounded the abortion right entirely on the 14th Amendment's Due Process Clause. The court did not reaffirm Roe's erroneous account of abortion history. In fact, none of the justices in the majority said anything about the history of abortion. And, as for precedent, the court relied on essentially the same body of cases that Roe had cited. Thus, with respect to the standard grounds for constitutional decision-making, text, history, and precedent, Casey did not even attempt to bolster Roe's reasoning. The court made almost no effort to remedy one of the greatest weaknesses in Roe's analysis. In a much criticized decision on viability, the court retained what it called Roe's central holding, that a state may not regulate pre-viability abortions for the purpose of protecting fetal life, but it provided no principled defense for the viability line. Instead, it merely rephased what Roe had said, stating that viability marked the point at which the independent existence of a second life can, in reason and fairness, be the object of state protection that now overrides the right of women. And so, clearly, without talking about the workability, and really we can wrap up the segment now on Roe, because the most important part of his case, without the beautiful summation. So I urge everyone that's listening to this to go to Politico to read the actual opinion on Dobbs v. Jackson women when it comes out, or now, and then when it comes out to actually read the opinion, go to the summary in the back, because it is very telling, and it basically says that there was no precedent, there was no history, there was no stare decisis, there was no constitutional basis for Roe to begin with. It was just something that the justices at that time decided that, in their opinion, they wanted to make law, and it was improper. It should have remained with the state through the legislature to make that decision. So, if you want to review the all 5 parts of this particular segment on Roe v. Wade, you can go to irlonestar.com, or you can go to our Facebook page, thelegaldetectionshow.com, and look up these particular cases. And you can actually zip through them if you want to avoid having to read this and get to the crux of the cases. So I will see you next Tuesday at noon. Remember, the most important thing you can do is to love God, to serve God by serving others, and we'll see you next week.